Goes with you. Goes with you. Goes with you. She goes with you. Goes with you.
So it's more presumptive for THC, benzodiazepines, and cocaine.
But I haven't done those, sir. Like, I haven't.
Sorry, Charlie. Goes with you. Sorry, Greg.
What was the third one, Judge?
Cocaine.
Oh, okay.
That's it.
What is the reset date, Your Honor?
He'll pop up on tomorrow's docket.
So Thursday or Friday, whatever.
So
day
yeah,
it is.
he'll pop up on Thursday's docket. I'm going to revoke the bonds. I don't know what they're set at now.
I'm in your court Thursday, so sounds good, Judge. I'll
Yep.
be there. All right,
Okay.
thanks.
Thanks, dude. You picked up a new case. You picked up a new case.
So,
Tell me there was a no driving affidavit in place. He's charged with failure to stop and give information, and now he's picked up a racing case. Tell me that we had ordered him not to drive.
Yes, Judge, on the previous case, there wasn't a driving affidavit.
You promised me that you weren't going to drive. Mr. Gonzalez, now you've picked up a racing on a highway. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Officers observed two vehicles accelerating at a high rate of speed from 70 miles per hour to 85 miles per hour in an attempt to outgain each other. The officer initiated a traffic stop on the defendant's vehicle. When the officer told the defendant that he was being stopped for racing, the defendant responded, "Yes, sir." And the defendant told the officer that he did not have a valid license or registration.
Is there a co-defendant?
There is not any co-defendants charged.
Vic, can I see that, please? I'm printing something out. What is that? What did you promise me you were not going to do? Guess what happens now, Mr. Gonzalez? Guess what happens now? Did you say nothing?
I'm not sure.
Not only am I putting you in jail now, but I'm going to make your bonds high. And now you are looking at a contempt charge of 180 days in jail. And we are going to have a hearing as to whether I'm going to hold you in contempt. So now I'm going to file a third case on you. And you are now looking, if they prove to me that you're driving in this case, you're looking at 180 days in jail, flat, day for day. Do you understand?
So,
Goes with you. I'm sorry, Sonia, but I'm setting the bonds at each at 10,000 and 2 each. And I'm going to make it higher. He was wearing an Armani shirt. He was probably wearing a $200 to $300 shirt right now. 15,002 on both.
Those reports being referenced were, there were follow-up lows that showed a declining level on those, unless I'm mistaken.
They go down and then they go up again on the.
Doesn't matter. It's no tolerance. We've been through this over and over and over. At what point do you get it, Mr. Jones? This is, how many bond violations do we have here now?
I believe this will be the third.
No.
Last time, I believe, Judge. That's why it's 7502.
Because I was generous with the 2 portion, but it's not just 2, Ben. We've had probably 5 or 6 bond violations. All I know is that you are testing positive you're in violation of your curfew again, what am I supposed to do? Just continue to let you go?
No, I understand that, Your Honor, but I don't know what I can say about the breathalyzer, sir, because I don't drink. I don't drink at all. I don't know why that the thing was doing that. I had to go back to the Smart Start place the next day, and because they have those little tubes that stick out of it.
I
But
don't,
I don't know. I mean, if you look at the test, you can see that I haven't failed any of my other breathalyzers, and even some of the breathalyzers will say like 1 minute it's failed, and the next minute it's like lower and then higher, and I don't know. But all I
have a
know,
confirmation of alcohol, Felicia?
From the portable device records, yes, they were provided to everybody in the email.
Judge, I've had an opportunity to look at those, just to clarify, in regards to that, there are other instances where we do have BAC readings, Judge, and there are follow-up blows that
Those were
show.
not confirmed as alcohol consumption.
And they will say, not confirmed. But we have some that are confirmed. He's blowing on his, or he's not
There
in,
was not a follow-up test on this positive, Judge.
no, I'm revoking your bond, Mr. Jones. It can't continue. No, goes with you.
I don't know what I can tell you, Your Honor. I'm not drinking or doing anything. Like,
I have evidence that shows me otherwise.
why can't?
And it's over, and it's over, and it's over, and it's over.
Can't we
This
put
is
me
a
on, like,
fourth,
the-
fifth violation that we have, Mr. Jones.
Why can't we put me on like the ankle monitor drug thing or something like that so I could prove to you that I'm not?
We had that.
I
We
never
took
had
it
that.
off.
No, I was never on that, Your Honor. I was.
Judge, if the court would consider
No.
additional conditions, Judge.
I have done everything in my power not to put him into custody. I have let him go over and over and over every time. And I'm done with it. I'm done with it. Something is going in your body that's causing it to test positive for alcohol. He goes with you. That's it. I told you last time, it's no tolerance. You're blowing your GPS, the curfew anyways. Goes with you.
I have had a chance to look at this violation report regarding Miss Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's seven, within that 7 or 8. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
hear-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, Your Honor. It's cold weather. I apologize, sir. Can I please speak on the breathalyzer?
No.
Just
You
told me
know
last
what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No.
And
It's you.
but to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate, for alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
And you come here and you ask.
Oh, they just told me about this last week in pretrial over there, and they said that I had
Look
the
at
45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please,
Telling me?
please, Honor. I will do
Something.
anything. I'll even go on that drug, ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know
Please give me a chance, Your Honor.
testing schedule is, and I've given you one
I started
pass
on.
after the other. He goes with you. No,
Oh my God.
Your Honor, may we discuss setting a new bond further?
of course.
Oh my gosh. Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera,
Yes, sir.
then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, fine. All right, 7502. I just don't get it. I truly don't. It's over and over and over. You are still skipping test. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping test. I mean, I have no other choice. I now have to revoke your bond again.
All right, well, then let's do a plea then.
Huh?
Let's plea it.
I agree with, and I'm okay, but I'm gonna tell you now that I want to have him TRAS'd immediately to see how we go forward.
Well, Judge,
You know?
okay.
Just,
Wait,
all I want you to do is not kill anyone, man. That's all I want, you know? Really, I'm not asking for much. You have, since day one in our court, have repeatedly refused to comply with bond conditions over and over and over. And I'm not doing a plea to where he can just get out and just do, and
So,
you scare me.
so how do we resolve, Judge?
Huh?
So how do we resolve it?
So, yeah, I agree with you. I think that the correct thing to do would be probation.
Okay.
But I would like to have him TRAS'd while he's in there. And I have a feeling I know what the TRAS is going to say, and that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
It's just costing him money, Judge. All it's costing him is his family money.
So it's okay to just skip task?
No, it's not. It's a test, but I'm saying
it's a
is
skip. I might just be asleep, but I'm not trying to skip him, Your Honor. I swear to
just
God.
stop talking. Yeah, you don't,
Sure.
just stop.
Okay, he goes with me. And it's literally, the minute he gets out, we have bond violations over and over and over. Now, what are we now, day what?
If the court wanted to be made aware of the presumptive results,
What did he test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
You tested positive for Oxycontin?
Yes, Judge, presumptively positive. It's being sent to the lab for the test.
He's got 4 open cases?
He has 4 open cases, Your Honor. The agreement that we worked out was a time served on the Fades ID and the latest criminal trespassing, and they're dismissing a criminal trespassing and interfering with it.
No. Why, you need to understand something, that you guys can work something out. I don't have to accept the deal. And I am extremely upset with you at this point because I ordered you to get a device. You did not get the device, did you?
I'm sorry, I thought I was actually calling. I didn't know where to get it from.
I told you to get the device. I ordered you to get the device. You did not do anything. And now you are here on a bond violation, not to mention 4 open cases. And now you want me to just take a proverbial slap on the wrist? No. You need to understand, Mr. Musadak, that actions have consequences. And
Yes, sir.
you not only picked up 4 cases,
I brought my dad here. He's here. Can you come with something?
your dad has nothing to do with this and will not save you from this. You have 4 cases and you failed to over and over and over to comply with bond conditions. I will not accept this agreement and I'm now revoking your bond and you will go to jail. Goes with you. Unacceptable. Unacceptable. You need to learn that actions have
I called. I've been working. I've been.
You today go to jail.
My client had tested positive for cocaine,
Come up, Mr. Burton.
methamphetamines, and marijuana.
We sent him for a drug test yesterday. He tested
Bond violation for the.
He tested positive for methamphetamine, cocaine, and what else?
THC.
No, sorry, goes with you. No, sir, it's unacceptable. Can't be using. I'm not gonna talk to you. We'll let you talk to your lawyer. You tell me, but I have pictures of,
The nature of alcohol can be mistaken for alcohol consumption. I know.
I have these pictures. It has no date. It
I
has
know,
no,
to give you context to it, I have the dates here. Those are just pictures of the close-up makeup, but he was DJing on those particular dates. And I have it right here because he just, like, I was trying to get it in the club.
and I guess drinking while DJing, right?
No, he said he wasn't. I mean, you talked to him. I wasn't there. It was DJ Sidney Ray, October 31st at this place, and that was the day in question. And then this is October, this one, I'm sorry,
Okay, so
October 27th.
I have here that you're consuming alcohol. I have here that the consumption is October 26th,
Yeah, that's the, I believe it's
October 30th,
in November 9th.
November 9th. Oh, and October 9th. So
That was, yeah.
I have 4 different events that you're consuming alcohol.
For October 9th, Your Honor, that was whenever you told me to put the scram on, and I put the scram on right after that. And then those other 3 dates.
So you're allegedly consuming alcohol the day I tell you to put it on.
No, he did it, that's the day, and then he put it on. No, that's the violation, we addressed that.
I have a positive for alcohol on the 9th of October.
Not from the scramble, I think.
Yes. I sent him on 10/9. So Felicia,
Yes, Judge.
so we sent him for a POC test on 10/9 on that time. Did he test positive for alcohol?
Yes, Judge.
Why on earth are we just now getting the violation?
The violation
No.
was already addressed.
That was addressed.
Yes, that violation was already addressed in a previous BVR. They started to put it in that section, that's why I didn't highlight it, but
Did I address that BVR?
yes, and that's when we amended the conditions to put a scram.
Okay, so now we have alcohol consumption as a second violation on top of all this.
For the scram itself.
I've been very grateful for the second chance you gave me. That was from the makeup that I applied to myself, and I was just ignorant to the fact that that would actually set off my scram device, but I've not consumed another alcohol beverage at all. Those are also the days that I was working, I was entertaining, I did not consume another alcohol beverage at all, so I've been very grateful. I'm not stupid, I wouldn't consume another alcoholic beverage after you put the scram device. in the
Mr.
cell.
Burrows, I told you at every single stage of this game, do not use, do not put anything into your body that could be positive for alcohol. It is your responsibility to know what you can and cannot use. You're old enough to know that actions have consequences.
Yes,
And
sir.
here we are. I've already let you go one time with a positive for alcohol. When I told you not to consume, you literally tested positive on the day that we sent you for the test. And now we have another 3 positives for alcohol.
I don't think that's all, that's the part, the other parts, yeah, but the first part, that's not, he didn't test positive.
He tested positive 10/9.
No, that was,
It was a positive urinalysis test, and because of that, we amended the.
And because of that, I amended the conditions. I did not put him in jail. I put the scram on him.
yeah, but we addressed that he didn't go in and like.
I got it.
It's not 2 tests, is what I'm trying to say.
Okay.
You're right.
but he's continuing to consume. Stephen,
The scram reports are also in your email. I'm not sure if you picked them, but we got the links to the records as well for all of those dates.
have you seen that?
I have whatever I was sent yesterday.
That's it.
I'm sorry, Mr. Bros. What am I supposed to do? Just let you go again?
No, sir, I'm not asking to, and I did not consume any alcohol. It was just yes, sir. The products that I put on, and I just was not aware that that was set off that. And it was makeup, sir. That's all it was. I didn't consume an alcohol beverage at all.
That party is 10:31 and I have here 10:26, 10:30, and you're telling me that you put this makeup on November 9th? Is that what you're trying to tell me?
Yes, sir. It's for my TikTok, and I have I had the videos of it also, sir. I do cosplay, and I just put on those products, and that was the sweat from it. I had no idea that that would actually get inside my blood system and and set that off.
You have levels?
Yes, they're in the scram report.
What is it?
I have
A peak of 0.08, and then.
He's a 0.08.
Yeah.
You're telling me that makeup made you a 0.08?
Yes, sir. And those are the days I was at work.
I don't believe it for a second.
I even have.
I don't believe it for a second. I'm sorry. A
Understand.
0.08 because of makeup?
Yes, sir. I understand. I promise you I have not consumed alcohol at all.
I'm sorry, dude.
I understand.
That's it.
Yes, sir. I understand.
With you?
I understand, yes, sir.
Can't possibly believe that makeup is going to make you as intoxicated as having 6 to 8 drinks. Sorry, Mike. You are on bond for a DWI. You've now picked up a new case. When is it going to stop? Let's go through your history, shall we? From 07, reckless driving, suspended license 12, suspended license, assault, VPO, felony continuous, endangering a child, ag assault, reckless driving, now a DWI. And while you're on bond for DWI, you've picked up now evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please.
Thank you, Your Honor. On March 30th, 2025, in Harris County, Texas, a law enforcement officer witnessed the defendant recklessly turn and nearly strike the law enforcement officer's vehicle. The law enforcement officer initiated a traffic stop, and the defendant evaded, as the DEM stated, the defendant evaded for 150 yards in the vehicle before being stopped. He couldn't go any further due to a valet parking lot. The defendant then exited his vehicle and fled on foot for 200 feet before being detained by the law enforcement officers.
So he almost hit someone. He's driving.
It looks like he almost hit the law enforcement officer.
So they attempt to pull him over.
Yes, Your Honor.
And he takes off. He gets out of the car and takes off.
Yes, Your Honor.
Did we have a no driving affidavit on this case? Do you know?
no judge, but we do have a condition. Don't drive unless you valid insurance license.
Does he have a valid license?
I'm rerunning it now, Your Honor.
I don't understand. If he doesn't, I don't know how we don't have a no driving affidavit.
Your Honor, I believe this number to be incorrect. It's coming back. The number in here is coming back as eligible average for a different name and shows that whoever had this number was reported deceased. So whatever driver's license number, that's right, Your Honor. I can see the picture now. This is an incorrect driver's license number that I have.
Mr. Estrada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now revoking your bond on the DWI. It goes with you. I'm now taking you into custody, and I don't know what I need to do to get your attention. Hopefully this is it, but all I want are my streets to be safe. And it's over to the tune of now 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Goes with you.
Your Honor, if I'm able to find a bondsman this morning, would you allow a walkthrough?
No, dudes.
I understand, Judge. Thank you.
Thanks.
She is not driving the vehicle, it's not drivable. We just need to switch her to a portable
Oh, no.
and a no driver.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car you haven't done anything and you're without any kind of devices whatsoever, right?
That was totaled and it's at my house right now, but I don't have I'm in a rental car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
This is not a good thing, Ms. Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
It's because she doesn't have a vehicle to put it on.
But you come back and you say, hey, Judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen. Ms. Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing, you know?
I understand. Would you consider setting her a new bond or
Of
default?
course, 5,001. So she has the first violation, right? This is the second time we have a bond violation, right? And the first one, was it that she just didn't get the device, right?
Yes, that's when we were going back and forth on the dates to get it, and we kept resetting the case because she said that she was gonna get it and then she didn't, and then we were gonna revoke her, but then she didn't come to court, so then we sent her again, and then she didn't get the device that day, so then we gave her another chance.
Okay.
And
All right.
Judge, I don't think I represented Ms. Lynch the whole time on that, but I think some of the confusion was she was ordered to get the in-vehicle interlock and she didn't have a card.
But you did come at the time to where
Yes,
she
correct.
did get the device
And then
within,
once Ms. Lynch because I believe the vehicle was damaged in an accident and she was hoping to get the vehicle out and get it repaired. And when she realized that wasn't going to be possible, she got the portable device.
My car's fixed now.
Yeah.
I started getting.
Okay, we'll get to that in a minute.
my concern is that it continues to happen. What am I supposed to do? The problem is if I let you go, I'm telling you the behavior is okay for you to do. It's not. We have court orders. You're supposed to follow court orders. You're doing what you want to do. That's not the way it works. Look, this isn't, I'll let you talk with your lawyer, but it's there. It's continuing to happen. You're skipping and you're continuing to consume alcohol. I'm sorry. I'm going to revoke your bond, man. She goes with you.
Judge, go back and I'll talk to you. Judge, since she does have a vehicle, if she makes the new bond, can we switch her from the portable to the in-vehicle?
Yeah.
Okay, thank you.
I'm here on Abel Morales, Judge. It's a probation on a DWI. There's an MRP. You sent him for a drug test. He wasn't able to take the drug
I'm
test.
revoking his bond. Come up, Mr. Morales.
Judge, he is forthright. When he left here to go take the drug test, he asked for the number for a recovery coach. So we,
I don't know. I ordered him to go take a drug test. You failed to do it. You didn't do it. There are consequences for action, dude.
I went. I just couldn't go.
he was there, he just couldn't.
I
use
stayed
the
till
bathroom.
5 o'clock.
They give you water. There's no reason why you can't go. I had a lady the other day, she had 5 bottles of water to be able to go. She was there for 4 hours. There's no reason why you can't.
I asked for water. They told me there's a water fountain that didn't really work on the 5th floor.
Judge, we know what the outcome of the drug test is going to be. He has not, he's been forthcoming with me from day one about that. And he does have a probation in writ court pending as well. And I
He's
think
still using Kavita. It's unacceptable. And I can't just let him go because he's just going to continue to use. He's going to continue to do what he wants to do. And it doesn't work like that. You've done nothing on your probation. I ordered you to go take a drug test. You didn't do it. There are consequences to action. And he now goes with you.
I understand, Judge, he is possibly going to go to status on writ court.
I think that's exactly what we need. No, that's what we need. And I'm going to tell you now, I will not let you go. I can keep you for the next 3 years until you come clean. We will continue to dance together. Do you understand?
Yes, sir. I'm not running from anything. I mean, I don't mind going to take a test right now. I just couldn't
sailed,
go.
Mr. Morales. I gave you the opportunity. That ship sailed. I gave you the opportunity on this DWI. I've given you multiple chances. You have literally done 0 while you've been on this probation. So, you want a back rub too?
I'm not asking for any leniency.
In life, when you put your heart and soul into it, you can achieve damn near anything. That's what's so great about this country. You don't live in other places where you don't even have internet. You can do anything you want. Mind over matter. I've given you chance, I've given you after chance, and you've repeatedly failed and you continue to use. Now you do it my way. It goes with you. Sorry, Kavita. You were on bond for theft.
Yes, sir.
And now you've picked up another. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
On February 17th, 2025, an officer was sitting in a Walmart parking lot and observed a male wearing a black jacket, red shirt, and brown pants running at a full sprint from the front of the store with what appeared to be a large box holding near his waist and trying to conceal with a jacket. The officer shouted to the male to stop running approximately 60 feet away. The defendant stopped, made eye contact with the officer, and entered the passenger side of a motor vehicle. The officer shouted for both occupants to stop, at which time the motor vehicle sped off, exiting the parking lot. The officer was advised by another officer that he was behind the motor vehicle at a Valero gas station parking lot. The defendant was detained and recognized as the same person observed to run away from the store. The complainant, a loss prevention associate, provided video showing the defendant walking past all points of sales with a speaker, total value $289, and the defendant was later ID'd by his Texas driver's license.
He's on bond for a prior assault.
For
Was
a
it-
prior theft, yes. Judge.
Right. Was that at the Walmart? And did we order him not to go to a Walmart?
That prior theft was from a Home Depot, Judge.
I can't continue to give you PR bonds, Mr. Mary.
Yes, sir.
You continue to pick up cases. What am I supposed to?
I'm picking up.
Stop.
Yes.
I'm not asking you to talk. I'm just telling you, I'm not going to continue to give you PR bonds. You're going to stay with me. You picked up a bond while you're on bond. I told you not to pick up any more cases. You've now picked up another case.
Nobody told me anything. The first time was,
Stop. I'm revoking your bond. I'm putting you in jail now. I'm going to appoint you a lawyer and we'll talk and we'll figure out where to go from here. But this is the 3rd PR bond now. No, sir.
It's not 3.
It's 3.
But it's not me though. I only have 2.
This is not a negotiation right now. I will appoint you a lawyer. I want you to talk to someone and then we'll figure out where we're going from here.
If you'd be willing to
In order of you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. Marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you set on that, Judge?
$5,001.
$5,001. And Judge, I have 2 more.
I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, this is the second. The first one was for the same thing.
Take your time, no rush. Deputy, ain't you going? We need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time? Unacceptable. He now goes with you. No?
What would you set his bond at, Judge? 5,000?
What's the last name again?
Flores, Judge.
Thank you. Yeah, 5,002.
5,000.
Yes. You were ordered not to use alcohol or marijuana. We tested you in December. You tested positive. I told you not to use anymore. Did he get tested today?
His mom is here, Your Honor, with him, just so you know.
Okay, where's mom?
Mom's in the corner.
Come up, mom. Do you speak English, ma'am? Yes. Thank you so much for coming. So you familiar with what's going on? So he's charged with a serious case. I told him not to smoke or use any alcohol, use marijuana. We tested him in December. He tested positive. I've tested him now. We are roughly almost 3 months later, and he tested positive again.
THC one more time.
Same thing. Sorry, bud. Goes with you. I told you not to use. And that's it.
Talk to you.
I got to show you that we're serious. I'm sorry, man. Yeah, 5,001.
Can I ask what the bond is, Your Honor?
Yeah, 5,001.
5,001?
No, you're not to use. I hope now we get your attention, but I don't know what else we can do. Okay, sorry. Goes with you. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well.
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Yeah, this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any Delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it. You know, at some point I become an enabler and I can't do that. I can't keep doing it, you know? So
Well, I mean, Your Honor, I understand you're revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. He has every intention of taking this case to trial. So I would, just, I'm not cheap, Your Honor. So if you could keep that into consideration on that.
And it's
I understand.
representing him in Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there.
Okay.
Yeah.
But tell him this, that he's lucky that they didn't revoke him on the first two cases, considering that he has an open, really, because, and I'm telling you now, I don't know how I didn't. You are on bond for murder and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the.
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
It looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the
magistrate. I wasn't aware
magistrate.
of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
There was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paperwork right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions. She received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, their curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting, so the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again.
Sure.
This is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do. I appreciate your tenacity, Mr. Leeper, but he has a DWI. He's got an FSRA where we have a dead body. He's not one violation. We're now working on our 2nd to 3rd violation, and now you're putting something, or I don't even know, but all I know is that the device lost contact with your leg for 2 days. That is unacceptable. When you have issues with a monitor, you bring it to your lawyer's attention, you come to court, and you say, look, this is what's happening. You don't put something in there in hopes that we're not going to notice. And now you tell your lawyer after the fact. I'm sorry, Mr. Lee, but what choice do I have but to revoke his bond again? I know that it's upsetting, but no, I have a very serious case with you. You've been ordered not, you know that there is no tolerance in this case. Yet, you lost contact for 2 days. I'm revoking your bond. Go to jail. Sorry.
What's his bond?
Mr. Leeper, I mean, I don't know. Judge, I'm not getting through.
Well, this is the other side of it too. He can't switch legs. He's got a GPS on his other one. He should have, I agree with you, this court, I agree with it, but something's good. We're gonna have to change something or even move him to like a full-time portable blow. Because it's not an alcohol issue, Judge. And, he obviously made the mistake.
I don't know that, right? Until you come here and tell me, I don't know. The only thing I know is we have a DWI, we've got an FSRA, we've got a dead body, and I've got multiple violations. And now you're hiding, you're doing something 2 days that I don't know about. You know what the proper procedure is when there's an issue. And you're just not doing it. You do what you want to do. That's not the way it works. And now you go to jail. Goes with you. I'm sorry, Mr. Leeper. I can't continue to justify it.
Fine, Judge.
He does bond out. We'll craft a different solution. I'm all ears, but I'm not going to let him continue to subvert.
What's his bond set at?
10,002. I mean, it doesn't make me happy, but I have to let him know that I'm serious, and you go 2 days, you don't have it. You've lost contact. I don't know what he's doing in 2 days.
This is the thing that frustrates me about these devices. He doesn't know he's lost contact. That's a whole, we don't get an alert saying that he's lost contact. He didn't know until this thing came in. And so it's on his leg. He's showing up to work. He's back home on time.
The device is snug to your skin. It's literally, it has to have constant contact with your skin. So for it to lose contact with your skin, there's something in between it, or they've done something to it. They've loosened it to where it's lost contact. They've put something in there. That's why it's impossible for us to know. The only thing that we do know is that it lost contact and it lost it for 2 days. Yeah, if it was our first rodeo, if it was our first, I always give someone the benefit of the doubt. But here we are over and over and over. And I've admonished him the last time, if you ever have any problems, you come to us. You don't do things on your own.
Thank you, Jeff. I agree, Steve.
I'm sorry, Mr. Lister. So, look, he'll end up bonding out. When he does, come back and we'll talk about it. And we'll figure some solution out. My only issue is that if I give him a portable device, is he's going to start skipping blows? That's why we had the scram. But I'm willing to give him an opportunity to let the leg heal, give him a portable device.
Keep him on GPS and keep him on curfew hours.
Same thing, but I'm telling you, if I start seeing skipped blows, we'll have an issue. You know? All right. I'm not happy with you, Mr. Johnson. You're on bond in this case, and now you've picked up a felony case. The only thing I asked you to do, behave yourself. Don't pick up any new cases. And now, Morgan, what has Mr. Johnson picked up?
Unauthorized possession of a catalytic converter.
Wow. What happened? Please.
So officers were dispatched to an apartment complex. The security guard in the apartment complex observed the defendant. Observed in plain view in the defendant's vehicle 3 catalytic converters that were freshly and jaggedly cut, and defendants were not mechanics. There's 2 defendants in this case. Defendant 1 was under a vehicle cutting the converter. When he saw security, he attempted to escape by jumping into a vehicle where defendant 2 was in the driver's seat. Security stopped them from leaving.
So where was Mr. Johnson?
I'm just trying to figure out if he was the number 1 or number 2 defendant, Judge.
Right, where was he? Was he in the car? How do we know if it's him? I don't want to try the case, right? But I don't want to.
Sorry, Judge. In the DIMS, they just identify the defendant 1 and 2. Let me just pull up the offense report really quickly. Okay, so Mr. Johnson was under the car. He was the defendant that was under the car, and then there was another defendant in a waiting vehicle.
So was he in the act of taking another one?
Yes, he was in the act of trying to steal a catalytic converter when the security guard caught him.
I am now going to revoke your bond on your first case. I asked you not to get in trouble. You've not picked up a felony case. Is there anything that you would like to add?
Your Honor, I would ask that the court set a bond, and obviously.
I understand.
Yeah.
That's, each one of those is like $5,000-6,000, and someone has to. Life's hard enough as it is, man. You know, really. It goes with you. Okay. 5,001 or 5,002. No, yeah.
Judge, I showed up and he is wanting me off the case. He wants a new attorney.
Jenkins, come up, please. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, he was on bond and there's a new offense, so we're here for an arraignment. And then,
so he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
That's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025 at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas driver?
Yes, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to address that.
wanted to have.
I'm not going to talk to you about this case. You have a lawyer.
I
You need
wanted
to talk to the
I wanted to talk
lawyer.
about my two kids before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today.
Anybody?
I'll give you a lawyer, another. If you want to get off, and I'll provide you another lawyer. It's the third case. Unacceptable.
And if I can explain a bit to the court.
First things first, though, is I have Mr. White that's been representing him.
Right.
And I guess, did I grant your motion withdrawal or we're having a hearing now?
We come back on Monday.
All right, so come on up.
So Will reached out to me on Wednesday. I spoke with Michael on Friday. I spoke with Michael on Wednesday. And so basically the understanding is that Will's gonna sub in and take over and I guess possibly resolve the case for today. I'm hired on to this new felony case that triggered this whole deal. I've agreed to sub in on this case to work out whatever's going on here, and I've been talking to Michael about that. The felony case is bogus for a lot of reasons, but talk to the state about this as well.
Well, hold on.
Okay.
Putting the cart ahead of the horse.
Okay.
So you went out.
Yes,
okay. You're out.
Okay. And I'm in.
Well, I don't know.
Okay.
You want me to appoint him a lawyer or do you want to?
I'm taking it pro bono because I'm hired on the felony and we want to just resolve this DWI deal today, probably.
Well, because here's the deal. I'm putting him in jail. You picked up a felony while you're on bond for a DWI. You're not supposed to pick up any new cases. You've now picked up a felony, an injury to a child, and it's just now coming to my attention, even though this thing's from November. I'm revoking your bond. It goes with you.
Okay.
Let's talk.
May I be excused, Your Honor?
Please.
Thank you.
Thank you, Mr. White. You did file a motion to withdraw, correct? Mr. White?
He didn't file it.
Aaron?
Yes.
Did you file a motion to withdraw?
Yes, I filed it last week. I saw it. I don't have it.
You now have picked up a new case, Mr. Arispe. You now stand charged with terroristic threat or a family or a household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officer was dispatched to a residence in response to a family disturbance. The complainant, the defendant's stepmother, stated that the defendant was upset because he was owed money. The defendant told other members of the complainant's family, if they don't have my money by tonight, I'm going to kill them, as well as I'm going to send my people to shoot them up. The defendant also told the complainant directly, if you don't have my money by tonight, you are going to see. A family member of the defendant and complainant stated that he had seen the defendant walking around with a pistol in his pocket, and the complainant knows that the defendant owned several rifles as well.
You were on bond for unlawful carrying of a weapon. Did we order him not to have one?
Yes, Judge.
Regardless, you picked up a new case. What happens now is I'm going to revoke your bond in the first place and you will stay with me. I will appoint you a lawyer today, Mr. Arispe, so we can talk about how to go forward, but I am ordering you now not to have any contact with these people. Do you understand? And I'm going to tell you, you pick up a third case, I'm going to go bonkers on the bonds. Do you understand? I'm going to do everything in my power to protect this public at all cost. All right, goes with you. Do you mind appointing him? Let me express my extreme disappointment with you, Mr. Poole. You are on bond for an evading arrest, a criminal mischief. You've picked up an aggravated assault of a family member and now a terroristic threat. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The defendant is the complainant's ex-boyfriend. During a walk-in report, the complainant told the officers that her and the defendant had an on and off dating relationship since the 8th grade, but they broke up in June 2024. In September, the defendant told the complainant, stop talking all that mess before I come to your house and to shoot you. The complainant told the officers that right after the incident, the defendant sent her photos of a gun in his lap. The complainant stated the defendant also told one of the complainant's friends that he was going to shoot the complainant.
So tell me about the ag assault. What happened there?
Your Honor, in the ag assault, one moment.
In the criminal mischief, is it with the same complaining witness as well?
The criminal mischief's from a prior event where we had experimented trying a drug and kind of got crazy and broke stuff.
Yes, Your Honor. And then for the aggravated
completely
assault,
unrelated.
it says the complainant and her friends went to a party, and at the party, they saw the defendant trying to get in, but was ultimately turned away because too many people were there already. While walking, the complainant ignored the defendant, and the defendant stated, "Are you going to apologize?" And the complainant kept walking. The defendant began cussing at the complainant and said, "I got it on me." And the defendant said the complainant said at that time, the defendant got a pistol from his ankle and pointed it at her. And then witnesses corroborated the complainant's statement. And Your Honor, there's also a pending terroristic threat out of Galveston as well for the same complaining witness. Yes.
Did you know about this?
I did not know about that.
Do you have an open case in Galveston as well? I think, Mr. Poole, that you are a complete and utter danger to our society. And I'm going to do everything in my power to protect Harris County from anyone that does any kind of damage whatsoever. I am now revoking your bonds on both of your other cases. Goes with you. I'm sorry. As much as I love you, it's unacceptable the way things have been going. And I think that you don't get the message. And now I hope you do. But I am now going to give you home confinement. You're not allowed out if you bond out of jail. I'm going to make your bond sky high. I think that you're a complete and utter danger to everyone. You flaunt our bond conditions. And it's truly sad, Mr. Poole, because you have but one life. And when you have a gun and when you start using that, God forbid that you do some irreparable damage, that you dig yourself into a hole where you're looking at 50 to 60 years in prison, perhaps life. 99% of people that are in jail are there because they have no self-control. They either use something, they are on something, and they get upset. They wig out without thinking, if I say this, what's going to happen? If I do this, what's going to happen? It's unacceptable. And now I will do everything, like I said, in my power to protect Harris County. So if you do get out, you must remain home confinement. You're not allowed out. No weapons, no contact with any of the complaining witnesses whatsoever, no dope, no alcohol. Anything else? I mean, what does he do?
He's a student, Judge. He's a high school student. So
I don't know what to tell you, man. I mean, he scares me.
Understood. And Chip and I are going to put some things together. I think that there's a different scenario really going on than what this reflects in the probable cause statements. And we're going to bring that to the prosecutors.
If you have something that shows me different to what they have, I'm all ears.
Understood.
And
with your permission, Judge, if we'll get some time to put that stuff together, we can perhaps readdress the bond.
Yeah, absolutely. And I never want to see a kid lose out on school, because to me, it's the most important thing in life,
Understood. If we do home confinement, can there be an exception to that when he's at school and he just has to report immediately back to his home?
Is he like in high school?
He's a high school student.
In high school.
I mean,
Yeah, Judge, he's actually currently, because of this situation, doing online school, so he'll be able to do it from home.
Oh, okay, good.
So disregard.
Good. There we go. Are you mom and dad? Come on up. Come up.
Come over close.
Thank you so much for coming. Shh. It's out of control. I don't know what else to do. But it seems that when he's out in public and he's out, partying, as they say, there's a wake of trouble. Did you guys know that he has a case in Galveston as well?
No, Your Honor, this is the first time I've heard of that.
Is it currently open?
It's currently open, Your Honor.
Something that the lawyers are also unaware of as well,
Well, we think it's all one event that happened over a few hours. We don't know.
But it's not though. It's not. He's, 12 in December of 23, we have a criminal mischief, an evading arrest. Now, a couple months later, we've got Galveston. It's not. And I think that we need to really give him a wake-up call before he really does irreparable damage,
If I could just clarify, the two events here in Harris and the one event in Galveston, we think that was all in the one series of events that happened between football games and a party on a hotel.
We need to figure out what's going on, to figure out why it's continuing to happen. I want what's best for your son. I really do. And I will help you in any way that I can. I have to put him in custody today because I have to show him that it's unacceptable what he's doing and picking up these tuna cases, especially the fact that he's picked up an aggravated assault. That's, you've got a great lawyer. We'll be here to figure it out with you.
And Judge, he's already addressed the bond on the felony case as well. So he's gone in and addressed everything with the felony. We're just
on, huh? So I'm making your bonds 30,000 each. I don't know if they're going to bond you out, but if you do get out, you better be on your best behavior, and you are not to go anywhere. What I'd like to do is, I'm going to take him in now. I'd like to do an evaluation. It's called a TRAS to see what the best way of going forward. We have clinicians that can sit there and evaluate him, talk to him, figure out what's going on, and perhaps boot camp is the right way. Perhaps, we have these other things that we have at our disposal to see how we go forward, because I just don't know. I don't know what's going on in his life. I don't know what he's doing, what he's taking,
We did already as part of the PTI, and they do want to increase him to what?
Say it again.
They want to increase his level of supervision to YMAX.
Who say that? The felony court?
No, misdemeanor, but this is a part of the PTI. He's already completed the TRS this year, so because of the new law violations and how things they kind of are, they want him to do YMAX.
Did you hear that?
I did. Judge, again, I think that these probable cause statements are giving a skewed picture of what's
So
really
that's
going
right. Let's not put the cart ahead of the horse. We'll give you time. And then if you see something different, just come back and let me know. Okay. Do you have any questions?
No.
If you need anything, always come back. We're here. We'll help you out in any way that we can. And sometimes some kids are harder to reach, but we'll do everything on our power to reach them one way or the other. So we got you. Okay. We'll take care of you one way or the other. Okay. All right. He goes with you. Oh yeah. I'm going to do a mow up. So hold on, Stephen, hold on. Mr. Poole, I'm entering in what's called the magistrate's order for emergency protection that identifies SM as a protected individual. You're not to commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where the person works. If you violate this court order, the state can and will file a violation protective order, and you violate those conditions, I can have a hearing to hold you at no bond. Zero bond, and I will do it in a heartbeat to protect every person of Harris County. Do you understand, Mr. Poole? Okay? All right. We'll have him sign it, and then